I've been in practice in this area of law for over 20 years, so I'm happy to have this opportunity to share my expertise with you. Right now, it's a unique time in our history with this COVID-19 pandemic, and the virus is making us have a lot of social distancing and separating us. It's also giving us an opportunity while we're at home and to get things organized. It's giving us an opportunity to get things off of our list that maybe we've thought about doing, but haven't really taken the time to do. And one of those is estate planning. And of course, with this COVID-19 pandemic, and sadly, all the people that are suffering from it, it's really important that we do have our estate planning documents in order, and further, that we as caregivers make sure not only those that we care for have their documents in order, but that we do. Oftentimes as caregivers, we're so busy taking care of everyone else, we don't take the time to take care of ourselves. And one of the best ways that we can do, one of the best things that we can do to protect those that we love is to have our documents in place to make it easy for others to care for us when a crisis hits. So what is estate planning? Estate planning is a general term to describe all those documents, legal documents that you need in order to protect your choices, your loved ones, your assets. These documents include a healthcare proxy, also known as a power of attorney for healthcare, a power of attorney, which is a document for financial choices, a power of attorney for pet care if we own pets, a will, and trust. And not only are having the appropriate estate planning documents part of what we need to protect our family, an additional component is to actually have access to them. Sadly, in my practice, I've often seen people who have taken time and have prepared the appropriate documents, but when the crisis hits, that document is in a shoebox under their bed or in a safe deposit box or somewhere inconvenient where the people that they have nominated to help them don't have access to. So what happens? All their estate planning is for naught. Now they have to get a court order to access the document in order to be able to achieve the goals that the documents created. So that's why it's a two-part process. You need to create the documents, but then they need to be readily available and accessible to the people you choose to make decisions for you. So currently today, it's very challenging. As I said, with the COVID-19, everything on lockdown, including the courts. So it's extra challenging. And under best circumstances, if you've completed your estate planning documents and your loved ones have access to them, if a crisis hits and you're incapacitated, there's a seamless transition. Someone can present their documents and start to take over and make decisions for you as you would want. When those documents are not in place, the court system has to get involved. And that's awful because there's an additional financial cost. But beyond that, and more importantly, is the emotional burden and stress that you're putting on your loved ones. Again, as caregivers, we care for everyone. We want to make it easy for them to care for us when we need their help. So we don't want to add an additional emotional burden. I mean, imagine it. You're in hospital and sick, and there's no one that can make a healthcare decision for you. They need to contact an attorney. They need to go to court. There's a financial cost. Instead of spending time with you at hospital, they're at court or dealing with the attorney. All these are added emotional burdens. Another factor that you may need to consider is conflict. Unfortunately, very few of us have perfect families. There are factions and power struggles always with family conflict. If you don't choose someone, you may be creating a situation in which your family members are going to be fighting to make decisions for you. You don't want this. This is why it's important to have decisions made ahead of time. Right now with COVID-19, the courts are dealing with emergency cases, and most certainly a guardianship, which is what would happen if you didn't have a healthcare proxy, or a conservatorship would be viewed as emergencies. But again, it doesn't happen fast. It doesn't happen fast when there is no COVID-19 pandemic. Now with this pandemic, it's even more challenging. So it's really important that we take advantage of this time when we're at home and to complete our estate planning documents so that we'll be ready if a crisis hits. And again, not only for the people we're taking care of, but for people who may at some point need to take care of us. Now, let's dive in deep about the critical, essential estate planning documents that you need. Beginning first with the healthcare proxy. Again, in some states, that's referred to as a power of attorney for medical care. This document has different critical components. First off, and most importantly, it enables you to nominate someone that you trust to make medical decisions for you, only in the event that you're not able to. So as long as you have capacity and as long as you can communicate, you're the one in charge of your medical care, obviously. However, what happens, as we've seen with this COVID-19 pandemic, what if you're on a respirator? What if something has happened to you, you've suffered a traumatic brain injury? You know, in life, we can't predict what's going to happen, but we can prepare. And that's the importance of having a healthcare proxy, that you've chosen someone, you've nominated someone to make your healthcare decisions. And this is your advocate who's going to be advocating your wishes in your most vulnerable state. Now, who do you want to pick to serve in this role? Obviously, you want to pick someone you trust, someone who knows you, who knows your values, who knows what's important to you, so that they will be able to make the best decision they can for you in whatever situation you find yourself. In addition to nominating a primary healthcare proxy, healthcare proxies give you opportunity to have substitutes. So if your first one, for whatever reason, couldn't do it, you can name an alternate and a successor alternate. Additionally, healthcare proxies can also have, which Gentreo offers, an advanced directive component, wherein you're stating what kind of care you want depending upon the circumstances. So, for example, if you were in a terminal illness and close to death, would you want life-sustaining treatment, such as, you know, dialysis or CPR or a respirator? If you were in a permanent vegetative state, which is, you know, a state of unconsciousness that the doctors have determined that you're not going to come back from, what kind of care would you want there? This gives you an opportunity to give further direction to your healthcare proxy about exactly what kind of care you would want. Now, sometimes people choose not to do that. People decide, I just trust my healthcare proxy and they'll make the best decision for me. And that's certainly your choice. The other option is to tell exactly what you would want. A further component of the healthcare proxy is to indicate whether or not you'd want a do not resuscitate order. Some people want to be revived or attempt to be revived, and other people would not choose that. It's entirely up to you, and you can make your decision, and your healthcare proxy can reflect those wishes. What's very important is that this document enables someone to make decisions for you in the event that you couldn't do it. For a financial power of attorney, this is very similar to the healthcare proxy, in that you are choosing someone you trust to make decisions for you. The difference is, unlike the healthcare proxy, this is in regards to your assets, your stuff, your possessions, your money. You are choosing someone to manage your money in the event that you're not able to. Again, a critical piece of this, when you're choosing someone to serve in this role, is it's someone that you trust. This is someone who's going to have access to your financial information, control of your money. You want to make sure that they are going to act in your best interest and manage your money in the way that you want. In a Gentreo power of attorney, you also have given opportunities to choose specifically what powers you want to give to your agent. So do you want them to be able to manage your real estate? Do you want them to be able to manage your bank account, your IRAs, whatever? You have a choice of having unlimited power of attorney or limiting it. You can also limit it not only by powers, but by dates. So for example, if you were traveling, like right now, if you got stuck overseas or whatever, it might be good to have someone stateside that could manage your finances for you, collect rents if you own property or whatever. So you could put a date limit on it as well as powers limit. Both the power of attorney and the healthcare proxy are documents that everyone over the age of 18 should do. There's no excuse not to, and everyone should have it because, again, it's going to make it an easy transition for someone to take care of you if a crisis hits. Now, for a will, this is a document which goes into effect after you die. Everyone over the 18 should have a will. However, it's not as critical until you own more things or if you're the parents of minor children. A will affords you the opportunity to direct where you want your possessions to go when you die, who you want to inherit from you. It also gives you an opportunity to nominate the person who would manage this for you. It's called a personal representative or an executor or executrix, depending upon the state you live in. Critically, if you're a parent of minor children, a will gives you an opportunity to nominate who you would want to raise your children if you were not there. This is really, again, a critical component because it avoids fighting and conflict, and you are in control. You are telling the court and telling everyone you love, this is who I want to raise my children if I'm not here. And really, as caregivers, that's the ultimate protection that we can provide for our children. So for all those reasons, you should complete a will. Now, a power of attorney for pet care. This is a document which, yes, it's relevant during this COVID-19 pandemic, but it's also important, hopefully, when life gets back to normal and we're doing a lot more traveling. This is a document that if you own a pet, you're able to say who you want to take care of your pet when you're not there. Further, you're giving that person the legal coverage, the authority to make decisions, perhaps emergency medical decisions on behalf of your pet. You're also able to limit the amount of money that you'd want to spend on emergency care and also make ultimate decisions. This power of attorney for pet care, not only does it protect you and your pet sitter, but also your veterinarian. And it's a good document to have as part of your overall estate plan. Lastly is a living trust. A living trust is a document which you create in order to transfer ownership of your items, your property, or other specific items out of your individual name and transfer them into a trust. Similar to how a corporation owns a business, the trust would own all your possessions that you transfer into it. And what it is, it's a way of avoiding the legal process known as probate. This is the word that describes what you need to do to get a will through the court system once you pass away. If you do a living trust and you transfer all your assets into that trust, what happens is the trust now owns that property. And under the terms of the trust, it's treated in one way when you're alive, meaning usually the person gets to have access to it. And then once you pass away, the terms of the trust take over and the property is distributed according to what you've decided within the trust. This is another way of holding your possessions and distributing them. Those are the critical estate planning documents. So this is a worst case scenario. you didn't do your estate planning. What's going to happen? As I mentioned earlier, you're putting your family and your loved ones in a difficult situation because they're going to have to get the court involved to have authority to make healthcare decisions for you and financial decisions for you. Additionally, there's a great possibility of conflict among your loved ones, and that causes the decision, a legal decision, to take longer to make, and ultimately these decisions may not be what you wanted, and all because you didn't indicate it. So what we're trying to encourage everyone to do is get all their estate planning organized and have it accessible, so when a crisis hits, there won't be these type of problems. And you save your loved ones not only the financial costs, but the emotional burden. Okay, Gentreo offers a great feature, and it's called the Gentreo Family Vault. Within that, you're able to store not only the Gentreo estate planning documents you created, but you're also able to store all your other relevant information that you would want the people that you've nominated to make decisions for you to have access to. So, for example, in the healthcare proxy realm, you would want your healthcare agent to know who your primary care physician is, who your cardiologist is, what medications you take. All that information can be stored in your vault. Additionally, by looking at the financial power of attorney, you would want your agent, also known as your attorney in fact, or the holder of your power of attorney. Those are all legal terms of art. But that individual, you'd want that person to know where are your monies held, who is your financial planner, who's your accountant, who's your insurance company. All that information you want to have readily available. And that's the beauty of having it all stored online in your Gentreo Family Vault. Additionally, you can choose through the sharing feature who you want to share what information with. That's really an excellent component to this, because no one person wants one individual to have all the information. It would be unusual. Usually you'd pick someone to make your medical decisions and someone else to make your financial decisions. So you would want them each to have the specific information that they need to make the best decision. Just because they're different people doesn't mean that they're not people that don't get along. You probably want to pick people that would work well together. The other feature at Gentreo is that in our life, things change, right? There are different life inflection points, such as you get married, you get divorced, you have a baby, someone dies. All these things necessitate updating your estate plan. With the Gentreo membership, you're able to adjust your estate planning documents as circumstances change. Further, if the laws change in your state, you may want to adjust your estate plan based on that. For example, right now, there are 3 states that don't allow a living will. If one of those states were to adopt a living will statute, you might want to adjust what your estate planning documents are. Thank you so much for joining us today at this Caregiving and Estate Planning webinar sponsored by Gentreo. I'm happy to stay on and take any questions that you have. What happens if the person I appointed as my healthcare proxy passes away before me? Well, in that situation, if you have not nominated an alternate, it goes to the courts. That's why it's important that you take the opportunity when you're completing your healthcare proxy to fill out your primary choice, your second choice, and your third choice. So you have 3 levels deep, and hopefully one of them would still be standing if you were in a crisis. How old do you have to be to do a healthcare proxy? It depends upon the state. Most states, it is 18. And I would say that's a good benchmark. There are a few states that if you serve in the armed forces or if you're married, you can do it earlier. But definitely by the time you're 18, you should complete a healthcare proxy. Particularly now, again, with the COVID-19 pandemic, sometimes our college students are across the country. We want to make sure that they've completed a healthcare proxy so that someone's empowered to make decisions for them if they get sick during this crisis. I am married. Do I really need this? Yes, you do. Um, marriage isn't enough of a legal protection. So, for example, there are sometimes situations in which you're married and your spouse doesn't get along with your family, and you're meeting your family of origin, your parents or your siblings, and something's happened now. You're in a permanent vegetative state, say you're in a coma and there's no chance of you coming back. Your spouse is saying, I know, using me as an example, I know Mary Kate didn't want artificial hydration and nutrition. However, your parents and your siblings could be saying, I know she did. So what happens? There's an immediate conflict. No one in the medical profession is going to be authorized to make decisions for you absent the court determining who your guardian is, which is going to be a fight between your spouse and your family of origin. If you had done a healthcare proxy, naming either your spouse or someone from your family of origin as your healthcare agent primary, that's the person whose decision would count. So you do need this. Also, in terms of finances, not all of us married today share everything jointly with our spouse. Sometimes, whatever, you come into the marriage, people get married older nowadays, so they might have an account set up, and for whatever reason, they just don't transfer it over to their spouse's name. So that money is left uncovered by the marriage. If it's held jointly, you're all set. But as I said, not all spouses own everything jointly. So a financial power of attorney would enable your spouse or whoever you nominate to manage that money that's not held jointly by your spouse. And in terms of the will, if you are married, your spouse does not get, depending upon the laws of the state, 100% of what you own. It could be split with if your parents are still alive or with your siblings. It depends upon the laws of your state. So for all these reasons, you do need estate planning documents, even if you're married. Next question, what happens if you do not have a will? So I just actually touched on that a little bit with the prior question. If you don't have a will, what happens to your possessions is distributed according to the laws of intestacy in your state. What that means is each state has its own law saying, under particular circumstances, who gets your stuff. And given that, again, we don't love our loved ones equally. Sometimes there are people that we are closer to than others, or sometimes there's been a terrible fracture or conflict in our family, and we may not be close to one sibling at all. Under a situation, if you were single and your parents were dead and you didn't have children, your siblings would share equally. So your sister that is your best friend and you talk to every day would get the same amount as the brother that you haven't spoken to in 20 years. A will is an opportunity for you to make your choices about what you want to happen with all your hard-earned money. Again, more critically, if you're a parent of minor children, it gives you an opportunity to say who you want to raise those children. Can your healthcare proxy and power of attorney be different people? Yes, they absolutely can be. And sometimes people choose different people on purpose in order to have sort of a balance of powers, that there's not one person making all the decisions for you. Again, it would be good, and you should think about this anyway when you're nominating someone to serve in this role, is you want to make sure it's someone that can work well with others, that can communicate and share information and be prudent in that sharing. So what I often see is that parents will pick someone who in their family who's in the medical field to be the healthcare agent, and then someone who's in the financial field or savvy with accounts or numbers or whatever to be the power of attorney. Does your estate planning cover digital assets? Yes. Gentreo offers that not only as one of the choices and the powers for a financial power of attorney, but also our will. Obviously, given the fact that we're an online company, we're at the forefront of all these legal trends, and one of which is authority over digital assets. That's something people don't think about. Who's going to be in charge of my Facebook account or Instagram or Bitcoin or whatever? All these things to happen with those assets, depending, the decision will be what your choice is. What are the most common types of trust? There are endless amount of trusts. The most common ones I'd say would be a living revocable trust, and an irrevocable trust, and a testamentary trust. In general, these three types of trusts cover what people consider when they want to organize their property. So for a testamentary trust, that comes out of a will. And sometimes, again, if you're a parent of minor children, or if you're a grandparent wanting to gift to minor children, you don't want the 17-year-old to get a boatload of cash when they're on their way to college, but you do want them to have the benefit of the use of that cash. So you set up a testamentary trust in which your grandchild or your child, depending upon whichever scenario we're talking about, would be able to have the benefit of that money through the trustee. Usually there's a provision in which the trustee says, has authority to spend money based on education, health, or personal needs. So of course, you could use the money to pay for a college education or whatever. A living revocable trust is a way of holding your assets and distributing them without a will. People do this to try to avoid probate and to just make it more clear cut. The challenge with that is when you create a living trust document, that's very easy to create. The challenge is funding it. You need to make sure that you transfer your assets to within the living trust. And that way the trust then owns it. But remember, when it's transferred, you no longer own it. It's in the control of the trustee, and the trustee can do what they want. So again, the trustee, like your agent, power of attorney, your healthcare proxy, this is someone that you really need to trust that they're going to take care of things for you. Lastly, the irrevocable trust is a trust that cannot be changed, that once the terms are set, you cannot change it. And the implications are for Medicaid and estate planning, in that sometimes our elders, they don't want to spend their money that they've worked hard their whole life to pay for their nursing home care. And the government has set up regulations which allows the elderly or others, if you have the assets, to transfer it out, all your assets out into an irrevocable living trust, so that after a certain period of time, which is 5 years, the state can't come back and try to take that money from you. And instead, the state bears the cost of any of your nursing home care. In general, I would say these are broad brushstrokes, the three most common types of trusts. Can you hire a professional to be an executor of your estate? Yes, you can. How? And you can also hire a professional to be a trustee. And just to be clear, it would not be you that was doing it. You could name an executor, like an attorney, or sometimes people take corporate trusts to be the person or the corporation that would serve in that role. And usually, if you want to pick someone like that, you would discuss that ahead of time so that they would know and be aware. And you, again, like anyone you choose to be executor of your estate, you'd want to make sure that they had access to all your information so that they'd be able to manage your estate once you pass away. Further, professionals, any personal representative or executor would be entitled to a fee if they chose it. More often than not, among families, they don't charge. However, just to be, full disclosure, a professional would charge a fee. Sometimes for people, it's worth paying the money to keep peace in the family to have a professional do it. In Massachusetts, does my wife automatically get my assets that I did not designate to her? Your wife would get an automatic first 200,000 in Massachusetts, and then after that, no. Does my power of attorney need to be a lawyer? No, absolutely not. It does not need to be an attorney or a professional. It just needs to be someone that you trust that's able to manage your financial assets. Again, it should be someone who's good with details, with paperwork, with money. That's who you want to choose. It does not have to be an attorney. And again, if you did choose an attorney, you'd be paying for that. How do I know if the laws change in my state, and would that require me to update my estate planning documents? In general, you wouldn't know that the laws have changed in your state. It's not surprising that, changes to estate planning laws don't make the first page of newspaper or website. With Gentreo, you would know because that's part of the service that we offer. We offer monitoring, and then we advise you about any changes that happen in your state. Once we tell you of the changes to your state law, it may give you pause and may want you to rethink some of your estate planning documents, but that would all be very fact specific. One of the things that we didn't talk about when we went through the will section is estate tax consequences. The federal government right now offers an estate tax exemption of over $11 million for an individual. So if you're a married couple, that's over $22 million. Most of us are nowhere near that type of assets. However, choosing Massachusetts as an example, Massachusetts only has a $1 million estate tax exemption. In Massachusetts, if you own a home and maybe have, some retirement savings, you could very easily hit that $1 million. And that might have impacts about your estate planning documents when you create them. Is there a limit to the number of documents that can be saved in the family vault? For example, can both husband and wife utilize one vault? Can my 19-year-old daughter have her HCP in the family vault? Or does each person need their own vault? So that's a very good question. First of all, there are no limits to the amount of documents that you can save in your family vault. Right now on Gentreo, we do not offer the possibility of a husband and wife sharing one family vault. However, if you want to give your spouse complete access to your vault and all your documents within it, you can through the sharing mechanism. So even though example of husband and wife, so I as wife have created my own Gentreo account, I have my own family vault, I can give 100% access to every single document to my husband. He cannot change it, he cannot add to it, but he can see it. Now, in terms of your 19-year-old daughter example, you can store her healthcare proxy in your vault, but she would not be able to access that unless you gave her permission to access it. We would recommend that every person have their own vault so that they can share their information with chosen loved ones. Well, thank you so much. It was great to be able to spend this time talking about estate planning and caregiving, and we encourage you to join Gentreo. We are offering during this COVID-19 pandemic a special discount for essential employees, which is $100 off. So it affords you an opportunity at a very low price point in order to be able to complete your estate planning documents and protect all those that you care about. Thank you.